I'm a lawyer and I don't know what the I'm reading. I am Ronald, the rules lawyer, and I'm going to give my best attempt to give an overview and some feedback on the first draft of the ORC license. ORC stands for Open RPG Creative License, that Paizo, the company that produces Pathfinder RPG, has hired a law firm to draft, which would be owned and run by no one company, and has the aim of fostering a collaborative game design community that includes tabletop RPGs and potentially other kinds of games. This was prompted by the OGL debacle, where Wizards of the Coast tried to revise what everyone understood to be a forever irrevocable license to allow people to publish derivative systems and materials for Dungeons and Dragons for 3rd and 5th editions. They tried to do that and were forced by the community to walk back on that attempt and to publish the current version of D&D under the Creative Commons license. I am a lawyer, but I am not a specialist in intellectual property law. So this entire video has that caveat. And also, I'm going to put my standard disclaimer at the bottom that this is not legal advice. However, I don't think I venture too far and make overly bold assertions in this video. Take it as you will. So let's start with why the ORC license is being developed. We begin with the OGL crisis. In response to what Wizards tried to do, more than 1,500 tabletop RPG publishers declared their interest and support for the development of a new open gaming license that had from the outset the goal of not being owned by any one company and being gaming system neutral, where game designers can, with confidence, borrow rules mechanics from other publishers, and also simultaneously make sure that what they innovate becomes available to future publishers and designers to foster a collaborative designer community. Wizards of the Coast put the current 5th edition D&D rules, SRD 5.1, published it under the Creative Commons license. Now, why shouldn't other tabletop publishers do the same? It is, after all, a license that is stable, that has been well established through wide use, and would allow a publisher to make their rules available for all future publishers to use and adapt. Well, to get to that, let's take a step back and look at what a collaborative design community involves. Here on the Creative Commons website, we see that there are several types of Creative Commons licenses. One of them is the CC-BY-SA license. This was not used by Wizards of the Coast, because if they had published the SRD under this license, then every other publisher that made content compatible with 5e or built upon it would have to incorporate the share alike clause. That's what SA stands for, in which everything they create and publish becomes likely similar for everyone else to use. And so, understandably, let's say a third-party company that wants to put out their own unique campaign setting would not want to use that version of a Creative Commons license, because then everyone could copy their characters, settings, stories, and plots. What Wizards did instead was to turn off the share-alike part and use this version of the Creative Commons license, where credit must be given to the creator, which is Wizards of the Coast. However, there is no provision inside this license for the derivative work, what the new publisher includes, for that to be shared or used by any future creators. For example, if a third-party publisher were to publish something 5e compatible, their work would be called adapted material. And this license does not have any provisions for how that third-party publisher's adapted material may be used by others. It only allows use of the original licensed material from Wizards of the Coast. This is explained in the FAQ, which they charmingly call the ORC AX. AX stands for Answers and Explanations. At the end, they say, unfortunately, when another company builds on their SRD, their innovations are trapped in their product and not automatically relicensed to the gaming community. This effectively kills the virtuous circle that open source communities are built on. So if that publisher wants to make its content available for others to use, they would need to hire their own lawyer and create a license. It's not precluded, this ability to have their content used by others, but they would need to write their own legal language that accomplishes that. However, that is a tricky thing to do, because as the Axe says, role-playing games infuse protectable creative descriptions with unprotectable game rules in a way that is challenging to separate legally. So to take one example where I think this is obviously true is the RPG 13th Age, where the book opens with icons, which are very powerful NPCs in the setting, and every character that is formed in this system has, as part of their character creation, a relationship to one of the icons. Now, this is arguably a rules mechanic and vital to building your character. However, it is also tied in inextricably with the setting of 13th Age. And when we look at Wizards of the Coast publishing the 5e SRD in the Creative Commons license, we see that they include Count Strahd von Zarovich, the antagonist in the Curse of Strahd adventure, their #1 adventure book, and that they include monsters that have traditionally been product identity to them, including beholders and mind flayers. So if Wizards of the Coast, a billion-dollar company, can mess up in putting out irrevocably their own product identity out, then any small publisher can obviously make the same mistake, publishing under the Creative Commons license. So this is where the ORC license comes in. As they say in their Axe document, they want publishers to not have to hire lawyers to publish content. They want them to simply be able to include this box that they give a sample of here in their publication, and by citing this license, the license does the work of dividing what is product identity in this paragraph and what is open gaming content or ORC content in this paragraph. You still can explicitly designate some things as your product identity so as to avoid doubt. Now, my main criticism of this draft is, hot damn is it hard to understand these distinctions, and one might actually need a lawyer to understand some of those distinctions. And it would help in the future for Azora Law to put out examples that illustrate what these distinctions are. There are some clear cases. Clearly, product identity includes artwork, delineated characters, worlds, and storylines, and proper nouns. Something that is clearly game mechanics and would be ORC content would be something like action resolution, methods of determining success or failure, including dice rolling. Those are clearly game mechanics and not copyrightable. One thing that would be a gray area is, let's say, classes, which are included under rules mechanics here, might have a name that refers to a character organization in your campaign setting. So in 2nd edition Pathfinder, we have the Red Mantis Assassin, which is not a class, it's an archetype, which is kind of like a theme a character can take in the system. However, in the 1st edition Pathfinder SRD, it was not called Red Mantis Assassin, it was called the Crimson Assassin. It had the product identity, the unique name from the setting removed from the class's name. Now, I actually don't know if this is open gaming content under 2E, but I'm just giving an example of something that could be a gray area. But that's probably more clear-cut than other possible situations. I'm just going to read some of these words, and most people now know what they mean. Open content includes heuristics, concepts of play. What does concepts of play include and not include? That I have no idea. Allowances and affordances, I'm not sure. Now, this license being confusing can be ameliorated through examples, which I ask them to put out in another draft. But I would put the blame for this situation prompting this kind of hair splitting on Wizards of the Coast through their conduct, which has put us in a situation where they need to draft a document that doesn't have an organization enforcing it, but stands on its own verbiage. That any future court, let's say Azora law ceases to exist at some point, and all of the companies involved in it cease to exist at some point, that some future arbiter can read the words of this document, and that the original intentions of the people who signed this document can be protected by that somebody in the 27th century, maybe on another planet. And so they want this document to be written in such a way as to be foolproof and to survive and to last as long as copyright law exists, as they even say in their Acts document, or the heat death of the universe, whichever comes first. They confess this to be their predicament here in the Acts document. We wish it were less complicated too. We opted for simplicity wherever possible, but when we were faced with a decision between precision or simplicity, we opted for precision. We want this to last for a very, very long time and resist all imaginable legal challenges. Thank you, WOTC. So in giving an overview of this document, we actually can see the reasons for them and understand them better in the context of the various sins Wizards of the Coast tried to commit as of late. So we pull up the first key word. WOTC tried to revoke the open gaming license and also tried to charge royalties and also try to include provisions, poison pills, in their both revisions of the OGL that could empower WOTC to end the license for anybody who used it. So this has the magic words of a worldwide, royalty-free, irrevocable license to use the licensed content. During Wizards' quote-unquote playtest of OGL 1.2, they had a bunch of provisions that allowed the entire license to cease to exist if the contract itself was found, any portion of it was found to be unenforceable. And there were other ways for Wizards to end the license for you. One of them being if you were to violate its terms. Here, in this draft license, even if you violate the terms of the license, use someone's product identity, if you cure the violation within 60 days of your discovery, then your license will be reinstated. So there is no ending the license forever. And there's extra language here saying the licensor waives any right to collect royalties from you. Now, this next part, I think, is the key and is still relevant to what WOTC might pull with the next edition of D&D. As people who've been following the controversy probably know by now, in order to make content open for the community to use and adapt, it has to be published in a document. Wizards of the Coast published the current rules, System Reference Document 5.1, under the Creative Commons license. However, that SRD is very limited. It's not nearly what you would get in the player's handbook alone. Every race has only one sub-race. There's only one arcane school for the wizard. Many spells, including Hex, are not included. It is actually unclear when Wizards of the Coast goes through its revision process whether the new rules, although they've promised they'll do this, whether the new rules will be published in an SRD under the Creative Commons license. Essentially, the publisher has to put out an SRD. The danger is that the new player's handbook, coming out next year, will have its 48 subclasses, but the SRD, let's say they do some updating to it, may only have one subclass for each class. And that act will make very clear that there is a wall around that SRD, and that those who borrow and publish compatible content for the new edition, that they'll need to be careful. Now, I won't go into it much in this video, but there may be a situation where Wizards really wants to heavily monetize its VTT. And competing VTTs like Roll20, Foundry, and Fantasy Grounds, they'll only have access to the material in the SRD and would have to sign a separate contract, maybe with heavy royalties to Wizards of the Coast, to be able to make other player options available to customers who use that VTT. So a publisher who wants to make not a subset of their book that they're publishing, but the entirety of the options in their new RPG system, if they want to make all of those available to future developers, they could publish it under the Creative Commons and include that language in their book. However, they'll open up the entirety of what's in their book for future developers. So the Axe says to the question, are there SRDs? It says, there probably will be the equivalent of these, but this license is designed not to require them. Because, well, remember, the ORC license already works to protect the product identity in your publication. And this license also says that everything that is mechanical, including the classes, professions, things that go toward your character, are all ORC content, open gaming content. No drawing a line around only a subset of your mechanics and character options and monsters and spells and magic items, for example. So what a publisher essentially accomplishes by including and using this license is a commitment to open gaming, that all of their product identity is theirs on the one hand, but on the other hand, all of the rules, mechanics, and innovations in what they've created can be used and adapted by others. In contrast to the Creative Commons license, making the third-party publisher's material, called adapted material, not available for future developers to use and borrow. There are simply no provisions providing for that. The ORC license draft says that your adapted ORC content, what you create, you hereby grant to every recipient of the adapted ORC content an offer to exercise the licensed rights in the adapted ORC content. So it allows the continuous, what they call a virtuous cycle. I like the word ecosystem, because what is produced, the precipitation comes back and feeds the soil and allows for more things to grow. Another key provision here is that when a publisher says X is product identity and it is arguably open gaming content, it is open gaming content. It says it right here under product identity notice. If you say something is product identity, in the event of a conflict between your designation of product identity and the definition of ORC content, the definition shall control. So what do I think about this overall? Well, this is definitely a step up and preferable to a publisher using the Creative Commons. This is an effort to create a Creative Commons license for the gaming community. This actually is not limited only to tabletop role-playing games. It can also be used by publishers of board games or people who make video games. They want a set of definitions that can make clear for publishers, present and future, what are uncopyrightable game mechanics and what is protectable product identity. By not requiring an SRD, it allows a publisher to actually make all of their content, the rules mechanics, available in an open gaming environment. One could do that with the Creative Commons license. However, every publication they put out would need to be published under the Creative Commons license. That was not true with the OGL with 5th edition. If you look at, as I said, the SRD did not include all of the options for characters in the system reference document. And if you look at the player's handbook, you'll see that it is not published under the OGL. It's not, there is no OGL notification. A company using the ORC license, once it's finalized, and if it adheres to these goals that they set at the outset, which almost certainly will, a company who publishes under the ORC license is going to actually be committing to open gaming. I think as a community, it behooves us to support all publishers who support open gaming and publish under the ORC license, and if they develop or publish under a different license, to give an explanation as to why, once this is finalized by the entities that are working together to develop this. Again, I give this with a caveat. I'm not a specialist in intellectual property law. I condition it on actual IP attorneys and other experts taking a look at this and, vetting the language here, separating product identity and rules mechanics. And I also say this with the caveat that Azora Law should put out examples that illustrate what these distinctions mean so that it is clearer to a layperson what these distinctions are, and so that we're not reliant on what a lawyer or a judge says or a company's PR spokesperson says. I fully endorse the goals, but it's the devil's in the details here, and I'll have to cede to greater minds, people who know more this area of law. I wish we could be in a situation where this language does not have to be as technical and confusing, and the Acts document would be sufficient to clarify the intentions of the words in the document. But again, Wizards of the Coast poisoned the well when they went back on trying to revoke the OGL 1.0a, because they had an FAQ back in 2004 saying precisely what everyone thought it meant, that it was irrevocable. But because they behaved badly, we're in a situation where they have to make a legal document that stands on its own. It also seems like publishers should publish under this because it will protect their product identity in their publication, unlike the Creative Commons license, and it allows future publishers to openly use all of the gaming rules, mechanics in your system and innovate upon them themselves for their own purposes, just as you can do to theirs. The process around developing this license allows the gaming community to define what is open content and what is not protectable as someone's property, instead of being at the whims of what a future court, who may be wrong, might say and do. So really, everyone should participate in this process, give feedback. There is a link that Azora Law provides to the Discord community where these discussions are being had, and you can interact directly with them. So I encourage everyone to go there and share their thoughts. And again, I'll just underline, for a community that has been aroused by what Wizards of the Coast tried to do at the beginning of this year, it behooves us to support open gaming, not just in TTRPGs, but in all gaming, to allow game designers to innovate on each other's ideas by requiring publishers to either publish under the finalized version of the ORC license, once we get a final look at it, of course, or to explain why they're not. So those are my initial thoughts on this first draft. If there is another moment to comment, I definitely will. If you're interested in my coverage of the OGL debacle and my thoughts on the future of the TTRPG industry, definitely check out the playlist that I will include on the screen. And that is it. I have been Ronald, the Rules Lawyer, and I'll see you next time.